Garcia, and our topic for today is entitled Some Labor Code Provisions Concerning Hours of Work, Rest Periods, Holiday Pay, Leaves, and Service Changes. In this topic, it plays a significant and vital role in the corporate sector. First to be discussed is under the Article 82 of the Labor Code of the Philippines, or the normal hours of work, wherein any employee shall not exceed 8 hours a day and should be exclusive of 1 hour daily lunch break. Under Article 84, hours work, it shall include A at all times during which an employee is required to be on duty or B prescribed workplace, and B at all times during which an employee is suffered or permitted to work. Under Article 85, it is the duty of every employer to give his employee, regardless of sex, not less than 60 minutes time off for their regular meals. These meals periods are not, however, compensable hours of work. The regular meals are breakfast, lunch, and supper. Coffee breaks or rest periods running from 5 to 20 minutes are not included. They are considered as compensable working time. Next is Article 86, Night Shift Differential, wherein every employee shall be paid a night shift differential or not less than 10% of his regular wage for each hour of work performed between 10 o'clock in the evening and 6 o'clock in the morning. All employees are entitled to night shift differential pay except of the following. Next is Article 87, Overtime Work. In here, work may be performed beyond 8 hours a day, provided that the employee is paid for the overtime work. An additional compensation equivalent to his regular wage plus at least 25% thereof. Work performed beyond 8 hours on a holiday or rest day shall be paid an additional compensation equivalent to the rate of the first 8 hours on a holiday or rest day plus at least 30% thereof. Last, in Article 96, Service Charges. In here, all service charges collected by the hotels, restaurants, and similar establishments shall be distributed at the rate of 85 for all covered employees and 15% for the management. The share of employees shall be equally distributed among them. In case the service charge is abolished, the share of the covered employees shall be considered integrated in their wages.
Meanwhile,
I am DIANNA AGSAOAY, Group 2, and my report is Relationship Determinants between Employer and Employee. The employment relationship is the legal link between employers and employee. It exists when a person performs work or service under certain conditions in return for remuneration. It is through the employment relationship, however defined, that reciprocal rights and obligations are created between the employee and the employer. It has been and continues to be and the main vehicle through which worker gains access to the rights and benefits associated with employment in the areas of labor and social security. The existence of an employment relationship is the condition that determines the application of the labor and social security law provision addressed to employees. It is the key point of reference for the determining and nature of existent employers' rights and obligations towards their workers. 4 elements of employer-employee relationship. Therefore, to determine the existence of an employer-employee relationship, and the fourfold test is usually applied. First is the selection and engagement of the employee. The second is the payment of wages, the power of dismissal, and the third is the employer's power to control the employee on the means and methods by which the work is accomplished. The four elements of employer-employee relationship, any competent and relevant evidence may be considered, including but not limited to identification cards, cash vouchers, social security, registration, appointment letters, employment contracts, payrolls, organization charts, and personal lease.
Okay, good afternoon, ma'am. My report is requisites of sexual harassment. So, requisite of sexual harassment is RA 7877 also provides the following must present in order an act in a work-related or employment environment be considered as sexual harassment. So, in an education or training environment, sexual harassment is committed against one who is under the care, custody, or supervision of the offender. So, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. So, it should be noted by any person who directs or induces another to commit any act of sexual harassment, or who cooperates or in the commission theory by another without which it would be have been committed shall also be held liable under RA 787. So the example is among LGBT workers, the member are substantially higher. A meta-analysis of workplace harassment studies conducted by the Williams Public Policy found that as many as 43% of gay workers have experienced mistreated on the job. So, parang yung para sa mga LGBT, this type of employee harassment is, for example, may nasabi kang mali sa kasarihan nila, magiging maaring makakaapekto sa kanila ito, which means this is the what we call sexual harassment kasi LGBT nga sila, tao rin naman sila kaya hindi natin pwedeng ganun-ganun na lang sila. So yun lang po, thank you po.
I'm Christian Mercado. I will discuss the types of employment. The different types of employment are as follows: regular or permanent employment, term or fixed employment, project employment, seasonal employment, and casual employment. The first one is the regular or permanent employment. Perform activities which are necessary or desirable in the usual business or trade of the employer. Have at least 1 year of service. Enjoy the benefit of security and tenure provided by the Philippine Constitution. Second is term or fixed employment. Present when the service is for definite period of time. This employment is measured by the commencement and termination. The fixed term employment must be highly regulated, subject to the two following conditions. First, parties must knowingly and voluntarily agree with the contract. Second, must be established to deal with each other between employer and employee. The third one is project employment. Hired for specific undertaking, it achieved the status of regular employment only when there is continuous rehiring of the same employer after a project has been done for completed. The fourth one is seasonal employment. Works are performed only for a certain time or season of the year. Encountered retail, tourism, hospitality, and other related industries. Two seasons in the hospitality industries: peak and lean. Regular season employees work during peak season and temporarily stop during. And the last type of employment is casual employment. This is not usually or necessarily related to the employer trade. The employees are terminated as soon as her contract expires. Should have 1 year of service whether continuous or not.
6.5 hours later.
I am Danilo si Cortez. From Group 2, I will discuss the worker basic rights under the Department of Labor and Employment. Number 1. Security tenure. Every employee shall be assured security of tenure. No employee can be dismissed from work except for a authorized cause and only after due process. Work days and work hours. Number 2. Work day refers to any day during which employee is regularly required to work. Hours of work refer to all the time an employee renders actual work or is required to be on duty or to be a prescribed workplace. Number 3. Weekly rest day. A day of 24 consecutive hours after 6 days of work should be scheduled by the employer upon consultation with the workers. Number 4. Wage and wage-related benefits. Wage is the amount paid to employee in exchange for task, piece of work, or service rendered to an employer. This includes overtime, night differential, rest day, holiday, and 13-month pay. Number 5. Payment of wages. Wages shall be paid in GCash, legal tender, at or near the place of work. Payment may be made through a bank upon right petition of majority of the workers in established with 25 or more and within 1 kilometer radius to a bank. Number 6. Employment of women. Night work prohibition unless allowed by the rules. In industrial undertakings from 10 p.m. to 6 a.m. In commercial industrial undertakings from 12 midnight to 6 a.m. In agricultural undertakings at night time unless given not less than 9 consecutive hours of rest. Number 7. Employment of children. Minimum employable age is 15 years old. A worker below 15 years old age should be directly under the sole 9 consecutive hours of rest. Number 7. Employment of children. Minimum employable age is 15 years old. A worker below 15 years old age should be directly under the sole responsibility of parents or guardians. Work does not interfere with child's schooling normal development. No person below 18 years old age can be employed in hazardous or deleterious undertaking. Number 8. Self-working conditions. Employee must provide workers within every kind of the job protection against injury, sickness, or death through safe and helpful working conditions, and thus benefits to work. The employees' compensation program is the tax-exempt compensation program for employees and their dependents created under Presidential Decree number 626, which was implemented in March 1975. The benefits include medical benefits, for sickness, injuries, disability benefits, rehabilitation benefits, death and funeral benefits, and pension benefits.